ADR is kind of like an umbrella term for dispute resolution tools like mediation, facilitation, mini trial, summary judgment, and that kind of thing. And it's used as an alternative to trial in the court system. And my fascination with mediation actually started a couple years before MIT, and I was working for the Boston City Councilor, Tito Jackson. And he worked on policy and he worked on the budget, but actually most of what he did was mediate between community groups and developers, between the city and organizations. And I started to realize as I watched him that when the groups sat down together and actually talked about their issues, the outcome was better and they lasted longer. And actually what the developer was proposing or the city wanted or the community groups wanted was worse than what they came up with at the end. And so when I got to MIT, I started thinking about other applications of ADR, and I thought, the court is an obvious place for this. How many cases do I know are not a yes or no plaintiff or defendant decision and really need creative solutions? But it turns out that I'm about 232 years too late for that thesis. And my friend Benjamin Austin wrote Observations of the Pernicious Practice of the Law in 1786. And in this, he talks about the need for impartial referees or negotiators or mediators between the groups. Now he actually goes much farther than I do, and he calls for the entire abolition of the entire practice of lawyers, so sorry.
So he's not my friend.
And his solution to this is to use judges, which I don't totally agree with, but maybe it was the right solution at the time. But what he does agree with me on are the reasons why mediation is a good solution. First is that it's less expensive. In 2017 in Massachusetts, the average mediation costs about $1,500 to $2,500 per party to mediate, while a trial costs between $50,000 and $150,000 to go through trial.
It's good for business.
Yeah.
It's faster. The average mediation lasts between 3 and 6 months inside the court system, while a trial lasts an average of 31 months. It's more satisfactory. A 1997 study of Massachusetts mediation programs that interviewed litigants found that 72 to 80% were mostly or completely satisfied with the outcome of the mediation, even when it didn't result in an agreement. And 92 to 100% thought that the practice was fair. And lastly, and this actually comes from my interviews and not from the pamphlet, but ADR allows for creative solutions and gets to the root issue of the problem. So let me tell you a story about this one, and this is a real case. There's a brownstone in the South End, and it's one of the rare brownstones that actually has a yard. And it has a view, not a great view, but it looks at the pike and the back of some of the buildings in the back bay, and the homeowner was really proud of this view. And a developer bought the parcel directly abutting the yard and proposed a 6-story building that went straight up and blocked the view. So the homeowner sued the developer, and they went to court. But instead of going to trial, they actually went to mediation. And in the mediation, it turned out that the homeowner was actually worried about his property values decreasing because the view was going to be cut off. So the developer proposed a solution. He would blow out the back of the brownstone, put in French doors, take out all the old windows, put in new, bigger windows, a new backyard, a new porch, and everything. And the homeowner loved it, went for it, and the developer got his 6-story building. And that kind of thing can't really happen in trial. Well, it turns out that the land court actually agrees with me and Mr. Austin, and in 1999 implemented their own ADR program. Now, originally, the program was actually inside the court, and so the judges would refer cases immediately to mediators. But through a series of lobbying issues, there's a new program. So in 2002, this program was implemented. And the court partnered with 5 court-approved private mediation programs that are located in private offices outside of the court system. And it's actually legally mandated that attorneys or the judges are required to tell their clients about ADR and the pros and cons of it. Judges can mandate screenings, which are sort of like informal information systems or sessions, but they can't mandate mediation itself. And the litigants split the cost of the mediator. So this sounds great. Mediation is great, the court has a program, so what is the issue? 47,111 cases were pending or filed in 2016. 71 were referred to screening, and 48 were mediated. Now I'm going to caveat this number a little bit and say that about 75% of the cases in the courts are what we call Service Member Relief Act cases, which are actually legally mandated for mortgage holders to file a case in the land court and make sure that the mortgage holders are not active members of the military, because it's illegal to foreclose on those people. But that's still a far cry from 48 cases. At least about 12,000 that I think could be mediated. And this leads to my research question. If ADR is less expensive, faster, and more satisfactory, why isn't it being used more in the Massachusetts Land Court? So I interviewed 6 of the 7 land court judges, 6 mediators, 4 of whom are directors of those court-approved programs, and 3 real estate agents. And they painted a picture for me about the barriers of ADR. First, it costs additional money. You've already spent a few $100s filing a case, you've hired an attorney, sometimes you've hired a litigator, and now you're being asked to pay more money. Secondly, it's outsourced from the courthouse. And a lot of litigants perceive this to be outside of the realm of justice because you're going to a private company that profits off of your case. And lastly, it's seen as a lose-lose situation. And the way that one of the judges described this to me was that he tells litigants, you can either go to trial, and one of you will be really happy, and one of you will be really unhappy. Or you can go to mediation, and you'll both compromise and be a little bit unhappy. So you can either be the person that's really unhappy, or you'll settle and be a little unhappy. And all of this is creates my main finding. And that's that ADR in the Massachusetts Land Court is perceived as second-class justice, as inferior to trial. And let me give you a hypothetical situation to explain this. Let's say we have 2 parcels. One is owned by Mr. Jones, one is owned by Mr. Smith, and they own a dividing property line. Now, Mr. Jones builds a pool and a shed, and he keeps his tools over that line. And Mr. Smith decides, actually, he owns that. Now they go to court, and this seems like a clear yes or no situation. Either Mr. Smith owns the land or he doesn't. But then the judge says, you two should mediate. And so now Mr. Smith is expected to pay more money to go to a private office that's not part of the court system, to sit before a mediator who's going to tell him to compromise and tell him that he should lose part of the land that he thinks he rightfully owns. That sounds like a pretty bad situation, and not one that I would want to be in. But if we think back to the brownstone situation, that was also a yes or no issue. Either the developer could build his building or he couldn't. But the mediation actually created a better situation for both parties. And in the pool situation, maybe Mr. Smith wanted to use the pool. Maybe he had a home office and he got sick of the kids splashing and it was actually the noise that was the problem. And maybe there was a creative solution that could have happened in mediation. And this is actually a real case. And in the real case, they went to trial, and Mr. Jones had to rip out his pool and tear down the shed. And they erected a giant fence down the middle so that neither of them could see each other. And a lot of times when they go to trial, it actually makes relationships worse. But ADR can really build relationships. But it's going to take a lot of effort by attorneys and mediators, the legislature, and the land court to address this perception. And so my recommendations are by actor. First, in my interviews with the judges, it doesn't seem like the judges really understand how mediation can benefit litigants. And so my first recommendation is for the judges and their clerks to go through training themselves and really understand how it works and how they can describe it. Second, the screenings are also outsourced right now with a few exceptions. And that means that litigants have to go to the mediators, and a lot of them perceive this as kind of like a sales pitch. You're going to the person that you're about to pay to do a service, and they're telling you that you really, really need this service. And so bringing the screenings inside the court may help alleviate some of that question. And lastly, I think the mediation program needs to come back within the court. A 2002 essay by Wayne Brazil, who's a judge and a mediator, did a huge survey on what kinds of in-court mediation programs works best. And it turns out that the closer the mediation programs are to the court, the more viable they are, and the more litigants perceive them as real justice. Now, in order to bring this back into the court, the legislature is going to have to pony up some money. But in 1999, the program cost about $350,000. And even though that was 20 years ago, the land court budget actually hasn't changed all that much. So I would be really surprised if this program costs too much more than it did in '99, and I think it would be worth it. Next, the attorneys should also probably go through some trainings, although they seem to have a better grasp of mediation than the judges did. But more importantly, I think they need to start bringing some of their clients to the courts itself. Right now there's a case management conference, and that's at the beginning of the case. And both the judges and the attorneys describe this as more of a scheduling conference. And so maybe that's not the best place for clients. But it is the place that all of the judges said that that's where they talk about mediation as an option. And so there should be something at the beginning where the litigants sit together in an actual room together and talk about possible settlement. And lastly, mediators can probably do all of the training that I talked about. And maybe that's through a video, and maybe through that's in-person trainings, and maybe that's just through brochures. And the Chief Justice actually asked for literature about mediation to pass out, which they have some, but they need more, clearly. And I also think that mediators could partner with some of the local law schools and both teach classes to up-and-coming real estate lawyers. But also, one of the mediators suggested partnering with the law schools and having the law students come into the court and help litigants learn about ADR. ADR is a viable and valuable option for trial for cases. And I think it's one that should be used more and is underutilized in the courts. It's faster, it's better in many cases, it's less expensive, and it's more satisfactory. And I think that's really what we need to address the 47,000 cases that we had. And in the words of the Robert Frost poem, good fences make good neighbors.